Peter Shimonik is next.
Good evening.
Good evening.
My name is Peter Shimonik, and I'm from Glastonbury, Connecticut. The first thing I'd like to do is, one of the things that I submitted into testimony is a petition that's been signed by over 700 disgruntled small number of parents. When you consider that there's 3,400 new cases filed in the family courts every year, I think 700 people is a large number. The other thing is that this wasn't lobbied, this isn't telephone calls, this isn't ads in newspapers, this is word of mouth. Every single one of these people has their own story. I come before the committee with kind of a unique perspective in that I've actually worked in the legal industry most of my life. I've worked literally with hundreds of attorneys. What's interesting is I'm not an attorney. I work on the business side of law. So I've helped law firms do business better. I've helped corporate legal departments pick the best law firms. And I can tell you that the system we have in our family court is a disaster from every single aspect. From the moment you walk into a family courthouse, the entire process is wrong. One of the things that I'll share from a background of a business person and a management consultant is that you don't use the same people that created a problem to solve it, especially not people who profit from it. And that's one of the biggest problems that we've had with some of the commentaries made from the divorce industry. The other thing I'd like to offer is that we're not alone. Connecticut is actually last right now in the country in terms of family court reform. This is published by the state of Kansas. 68 pages, Guardian ad litem handbook. Laws, regulations, what guardian ad litems can do, what they can't do. One of the most interesting things of this packet, this is published in August 2013, the state of Kansas created a citizens review board. A citizens review board, staffed with citizens that report to the judiciary to look into complaints against family court judges and guardian ad litems. Think about that. This is what we need in this state. Because when you have a situation where you have AMCs and GALs working hand in hand with family court judges, most of them who used to be GALs, you get the expected result. One of the things that you may want to do is go up to the court system's website, the family court, and look at the family commission. Just look at it. There's no one here in this room that can talk to a judge. We can't write a letter. We can't complain to them. And yet on the family commission, we have judges, family court judges, talking directly with full-time guardian ad litems on a regular basis about individual cases. Why is that allowed? We had commentary from former Supreme Court Justice Ian McLaughlin talking about judicial independence. Where is the judicial independence? When you have people whispering into judges' ears about individual cases. That's not independence. That's wrong. If we basically look at Bill 494 and what needs to change, I think it's a good start. I think it's a framework. But it's well behind what it actually needs to do. And we have 6 recommendations, or I have. 1, you have to break the bond between AMCs, JLs, and judges. One of the recommendations I think I made about a year ago is you can eliminate a lot of the atmosphere of corruption overnight without spending a dime. Basically, have a computer next to the judge. Next time you need a GAL, he presses a button. Whoever the next GAL is, that's the GAL. Why are judges allowed to assign GALs by name? Get rid of the patronage. Get rid of the atmosphere of corruption. Make it a random draw, just like a juror. The next thing we need to do is get rid of the profit incentive. As has been pointed out by a number of people, guardian ad litems are supposed to evaluate every single child according to 16 set criteria. It doesn't matter if the child's a child of a millionaire or a child of someone on welfare. It's the same set of 16 criteria, the exact same work, the exact same job. So why do they bill by the hour? Have a fixed rate, $2,500, $5,000. As I think someone else pointed out here, a guardian ad litem working at $50 an hour created a 20-page report in 4 weeks. This is not rocket science. This is something a high school student can do. Why are people being billed $25,000, $50,000, $100,000 for what amounts to nothing? And it is nothing. These people are not meeting with the children. They're not meeting with the therapists. They're not meeting with the doctors. They basically are taking the exact same boilerplate document, changing the names, and submitting it to the court. I've seen this happen over and over and over again. There's no work product involved. Third thing, the state of Connecticut is unique in the country And this is one of the few states where just because a guardian ad litem is assigned to your case, every single one of these people is automatically deemed invalid and incapable. Think about that. Your parental rights are taken away from you just because a guardian ad litem is assigned to your case. Does that make any sense? Third thing, AMC guardian ad litem fees have to be defined as consultant fees, not child support. Child support is payment from one parent to another for the support of a child, not to a third party. There isn't a single dime that's ever been paid to a guardian ad litem or AMC that's to the benefit of the child. It doesn't clothe them, it doesn't feed them, it doesn't shelter them. On the contrary, we've had people who have lost their homes, lost their jobs, lost their retirement accounts. I had my son's college funds taken away from me under the threat of arrest. Think about that for a minute. You work all your life to put money away for your child for a college, and in an instant, that money's taken from you, or you're going to be thrown in jail. How would you feel? How would you feel? This is happening every single day in our family court system. We saw it happen just last week with court watchers. Next point, any kind of payment dispute that exists between a parent and a guardian ad litem or an AMC should be taken to civil court, not family court. It's no different than any other business dispute. So let me ask you this question. If people are arguing against this, why is it that family court judges aren't intervening when parents don't pay their therapists? It's only the AMC GALs that they take care of. No other court-appointed official. This is why we have mental health professionals in this state who don't want to be GALs. They've told me point blank, the reason they don't want to be a GAL is because the judge is always going to pay the attorneys, will never make sure they get paid. How does that make any sense? Why do we have a two-tier system? Finally, eliminate immunity. Enforce accountability. Now, right off the bat, everyone's going to scream. Let's look at the state of Maryland. The state of Maryland had this exact same problem in 2006. Their legislators had the courage to get together and say, you know what? Let's get rid of immunity. What happened? The divorce industry screamed. Oh my God, parents are going to sue every single week. There's going to be bloody children walking the street. That's what the divorce attorneys, that's what the divorce industry said. What actually happened? Within 2 years, all the bad, unethical GALs left the system. The people that wanted to stay and work at state rates and actually spend 100% of their time with the children stayed in the system. Within 3 years, the average length and cost of custody cases in that state was cut in half. Do you think there's a cause and effect? Final point. Think about this concept. In this state, guardian ad litems are not mandated reporters. A guardian ad litem has no obligation under state law to report abuse or neglect of a child. Think about all the horror stories you've heard here. The reason why the guardian ad litem is not reporting this to the court or not reporting it to DCF, they're not mandated reporters. So what are they guarding? In summary, this is the situation we have here in the state of Connecticut. Bill 494 is a framework. You need to flesh it out. Thank you.
Thank you for your testimony. Can you repeat your third point for me, your third recommendation?
I'll send this around if you'd like. The third point is that basically, in the state of Connecticut, we're one of the few states where just because a guardian ad litem is assigned to your case, now mind you, if DCF is assigned to your case, what's the very first thing the DCF person does? They hand you a pamphlet, here's your rights. When a guardian ad litem is assigned to your case, you get nothing. You get blindsided. You just automatically have a guardian ad litem assigned to your case, and from that very moment, from a legal perspective in the state of Connecticut, and there's case law that says this, the guardian ad litem trumps your right to be a parent. They can actually make medical decisions for you. They can make educational decisions for you. You are no longer the parent of that child. That is absolutely wrong.
I think Representative O'Day was interested in your fourth point, and let me know if I've recorded correctly. I have your first point, as you put it, break the bond between AMCs, JALs, and judges. Secondly, remove financial incentives. Third, I think you just said publish a guidebook for the role of GALs.
It's correct, and basically eliminate the assumption that a parent is incapable or invalid just because a guardian ad litem is assigned. There needs to be some kind of determination that both parents are not capable. And if you think about it, if you go back to 1974, the federal bill that was passed by George McGovern that created guardian ad litems across this country, that's what the intent was. The intent was that you have two parents in a case that are absolutely invalid and incapable of taking care of a child, In that instance, you would assign a guardian ad litem paid for by the state. That's the intent of the law. It's been manipulated and twisted completely out of proportion.
Fourth, I have take payment disputes between JLs and parties to civil court.
That's number 5. Number 4 is that AMC JAL fees must be defined as consultant fees rather than as child support.
Okay. My 5 was eliminate immunity and enforce accountability. And then 6, guardian ad litem should be mandated reporters.
Yes.
Okay, thank you. Others with questions? Representative Gonzalez.
Thank you. Peter, I I heard a story about a judge with a guardian ad litem. I think that one of the parents went into court. Well, we was going to court, and the judge sent a note or the guardian ad litem. Do you know that story?
I've heard incredible stories about, and this is one thing that I mentioned to people, is having worked in the legal industry, I've been in the courthouse across the street, and what I'll share with the attorneys that are on the Judiciary Committee, if you really want your eyes open, walk into a family courthouse any day of the week, just plain clothes, and sit and listen for 2 hours, your head will explode. You won't believe what you're hearing. Attorneys that are in the system that assign this petition, we just can't believe what we're seeing happening. It's a complete denial of due process, complete denial of civil rights. What we've seen happen in the family court would not be tolerated in any of the court of law in this state. Why does it allow it to happen in a family court?
I think that, and correct me if I'm wrong, I think that I think that we discussed a guardian ad litem, very well known, that charge six clients, 6 parents, the same day, the same amount of money. And when we did the math, it was like she was working like 14 hours a day.
This is one thing that's very eye-opening to me, is in the corporate world, what I specialize in is legally billing. To explain what that is, picture the Hartford Insurance here in Hartford. They do business with literally thousands of attorneys across the country. The company that I ran would basically work as a MasterCard or Visa for legal invoices. So you as an attorney, instead of sending your invoice on paper to the Hartford, would send it electronically, we would process it, and the Hartford would pay you electronically. What that allowed us to do is look at the legal bills on a line item basis and uncover what you're just describing, attorneys that were double and triple billing for the same amount of work, which is unethical. One of the things that just absolutely struck me when I was looking at some guardian ad litem bills is I literally have a stack this high from parents. I'm going through it, and it just struck me as to what I was looking at. It dawned on me that almost every single guardian ad litem bill that I was looking at was not generated from a legal time and billing program. Even attorneys that I know work at law firms that have legal time and billing programs because I used to install them. So the question is, why is a guardian ad litem typing up a bill in Word rather than generating it from an accounting system? And the answer is clear. One, they're double or triple billing, that's obvious. The second thing is they're keeping double books. And what we've uncovered is you'll have guardian ad litems that are billing $250, $350, $450 an hour, yet what ends up happening is at tax time, they're claiming they're being paid at the state rate at $50 an hour. It's a massive tax evasion scheme. This is not ifs, ands, or buts. This is black and white on paper, and this should be investigated as well.
If from Stanford here, guardian ad litem will charge, well, this guardian ad litem will charge $600 for transportation. And so she will charge $600 to all 6 clients the same day.
We saw a particular guardian ad litem who was actually in this room who had 9 hearings scheduled for the same day, even worse, for the exact same time. I mean, how is that even possible?
That's what I was looking for, because I do have the information about that.
So one recommendation is, one of the things that just amazes me is nowhere does the state or the family court system track what guardian ad litems are paid. Nowhere. There's no database, there's no record, there's no mandated requirement that they submit their bills anywhere. The only place that you can see what a guardian ad litem has been paid is by literally looking at the court transcripts one at a time to see what the judge says. How does that make any sense? One of the reforms passed in the state of Maine last summer is they now have a publicly accessible database where every single guardian ad litem needs to submit their bill to show what they've been paid and how much time they actually spend with a child. So you avoid a situation as I'm in with my latest guardian ad litem, who billed $26,000 and spent all of 3 hours with my sons. How does that make any sense? Does that represent work product? Does that represent effort in the best interest of the child? And yet this exact same guardian ad litem was in court in December arguing that she should be that she should be paid as child support. She's done absolutely no work on this case whatsoever in about a year. The last time she met with the children was last January. She testified last June as to what was in the best interest of my child, not having even spoken with their therapist, pediatrician, or school system in over half a year. Does that make any sense? Does that reflect work product? Does that reflect excellence in legal representation? It's horrific. And this is not unique. These people's stories are not unique. This is going on every single day, and this is why I say, do what Minnie's done. Go to a family courthouse and just sit there for 2 hours and listen. Just listen. I think if you're an attorney, you'll be in shock.
Well, I'm not an attorney. I was shocked. But then they were saying that I was intimidating the judge, which I believe that if I'm looking for changes and I want to be sure that we come up with the right changes, I believe that the right thing was to go to the family court and watch, and see what was going on. It's a lot of stories, and people saying that that all these stories is because the people are not happy and not satisfied with the result in their cases. And I decided to go and see by myself, and check. And I went to a lot of court. I went to New Britain, I know Hartford, Middletown, and I did, watch. It was a joke, but it's sad that the people don't believe in the court system. But it's not that people don't want to believe in the court system. It's that it's scary. You don't have the money to pay, and they will put you in jail.
And it's an amazing point. I mean, I've heard we heard the parent who said that their father was a Marine. I was born in a communist country. This is not why I and my family came here. I mean, I've heard horrific stories, point blank, of parents that were told by a judge in a courtroom, if you mention your case outside this courtroom, you'll lose your child. There's cases where a parent was told, do not talk to your child about God. I mean, I'm not a religious person, but I know that's wrong. How does a judge get away with saying that to someone, to a parent? I don't get it. This is happening here in the state of Connecticut. I mean, we actually have a joke among ourselves that there should be a lawsuit preventing the state from calling itself the Constitution state. That's how bad this has gotten here.
And I believe that the one that they prohibit to her to speak about religion, she ended up losing the kid because she told the kid, God will help us. And then right away the next day, our guardians ad litems, they were in that court, they went straight to the judge. Well, she said, God will help us. And the next thing that she knows, the kid is out of Connecticut. But that's the system, and I believe that that's what we're all fighting for, to do changes, to see it get better. Other than that, the people from Connecticut, they really, going to the court is terrible. Going to the court, these people are so scared that it's like I was saying a couple of weeks ago, that I have a person that she told me she wet her clothes when she went to court and she heard the name of the judge.
Well, and think about it. Why should people be afraid of their family court system? I mean, you should respect the judge, you should respect the attorneys, you should respect everybody, but to be terrified to go to a family court? I mean, I've been in that scenario. That's not a good thing. It's absolutely not a good thing. And again, that's unfortunately the situation we have here. We have judges who act like bullies. I mean, I've been in a courthouse where I've seen a judge yelling and screaming at a parent. I mean, that wouldn't happen in a civil courtroom. And yet it happens in family court every single day. The other thing that I'd like to respond to is, again, this is not an attack on the legal profession. It's not an attack on attorneys. We have very many attorneys, even family law attorneys, that are part of this. And to me, one of the sad parts of this whole scenario, being from someone from the legal industry, is we've literally lost an entire generation of young family law attorneys who gave up. One of the other things that you'll see in the family courthouse is the average age of a family court attorney that's in the courthouse right now is well in their 50s. That's not good. 70s, I mean, really, it's a really bad system. And this is why a lot of family law attorneys, my young attorney right now, is at the point where he's willing to give up. He can't make a living in this anymore. It's created this self-defeating death spiral where the number of parents that can afford to pay for their family attorneys has dropped dramatically because of what happened in Wall Street. And yet the bills are being jacked up, and that's why people are being shaken down for every single dime they're worth. I mean, the worst one that I've heard so far, and I thought I heard something really bad, was a gentleman in Westport whose guardian ad litem bills right now is $400,000, and his guardian ad litem is billing at $575 an hour. $400,000. That's a house on one case for this guardian ad litem. I mean, it's outrageous. With no caps, no controls, to do what? To prolong the case.
Thank you, Peter. Thank you. Thank you very much.
And I just want to mention that your appearances in the courthouse have made a difference. And again, just to illustrate, this is not a problem just here in Connecticut. A task force in Delaware and the Chief State Justice in New York both came out with the exact same recommendation last year, and that was to open up family courts to audio and video recording to eliminate the atmosphere of corruption. Think about that statement coming from a Chief State Justice.
I think that would be good also. If they're going to remove a child or they're going to terminate the parental rights, I think that we should have a jury decide that. Because in court right now, we have the judge and the guardian ad litem. Those two, they decide. So I think that we should have a jury to decide to make that kind of decision.
And it's too much control in a very small group of people. That's the other problem as well.
Yeah. Thank you.
Other members have questions? Seeing none, thank you, Peter.